Good afternoon. My name is Tom Azoni. I'm a partner with Secrest Wardle here in Troy, Michigan. And today's webinar is about the open and obvious hazard defense as it currently stands in Michigan. I'm recording this in a bunker deep below our offices in Troy, and so unfortunately you won't be able to ask questions during the webinar, but please feel free to contact me or my partner Mark Masters at the number on the screen, or write to us either with questions, or if you don't yet have the 2014 update to the Premises Liability Handbook. It's free for the asking, and it's pretty good if I say so myself. All right, next. Take a look at this screen carefully, if you would. This is Mark Masters' house from a number of years ago. He took this picture, and you'll see he was having his front porch replaced, and I think he was doing this work himself. Let's assume he was. So he's the owner who's doing work on his own home. You'll see he's placed this caution tape around the front of the porch to warn people to stay away. And in the daytime, clearly this area is quite obvious in terms of its trip hazard. But look carefully on the door. Despite the tape, despite the hazard, despite the broken concrete, someone has managed to put a flyer on his door. As it turns out, that flyer was for pizza coupons from a local pizzeria. Now, if that delivery person, let's say a young man, if that young man had tripped and fallen on the broken concrete in the course of delivering that coupon, the question is, well, does he have a cause of action under Michigan premises liability law? And the answer is no way. The Michigan premises liability law, the open and obvious hazard rule portion of it, is designed to shift sole responsibility for injuries to an injured person when those injuries arise out of a defect in the premises and the injured person either knew of the hazard or the hazard was so obvious that it would have been able to be seen and avoided by a reasonably careful person. And without question, a reasonably careful person would have been able to see and avoid this hazard, and the open and obvious hazard rule would have prevented that person from succeeding with the lawsuit. He would not have gotten past a motion for summary disposition. So first of all, let's talk about the term. We talked about defect in the premises. Well, what does that mean? Well, when we talk about that phrase, we're talking about land and things that are permanently attached to it. We're going to come back to that issue and that definition time and again, because it's that very aspect of a premises case that distinguishes whether a plaintiff is able to overcome this open and obvious hazard rule or not. So the first thing you need to know is this rule applies in premises cases only. You'll know if you ever get products liability cases that there is a rule there where there are cases there where the rule applies. But in the main, when we're talking about a negligence action, this rule is going to apply to premises liability claims only. And a premises liability claim involves defects in the premises itself, which is the land, and things that are permanently attached to it. All right. We're going to get into the actual elements of the open and obvious hazard rule, but first you need to understand where it fits into the legal landscape of a general negligence claim. So in Michigan and in, I would say, all other states, there are four elements to a negligence cause of action. There's duty, breach of duty or negligence, proximate cause, and damages. Well, when you see that first element, duty, know this, that it's not simply listed first, but it is first in hierarchy. That is, in deciding if the plaintiff gets to bring his or her case to a jury, a trial judge would look first to confirm that the defendant owed some legal obligation or duty to the plaintiff. If no, we don't go any further and we don't consider whether or not the defendant was negligent. Only once the court's satisfied that a duty was owed do we go on to the second step and consider whether the defendant was negligent. Well, why is this important, or how does this work? Well, consider a trespasser. In Michigan, a premises owner owes no duty of care to a trespasser. So if we were to think back or go back to Mark Masters' front porch, and instead of this scenario where a delivery person is delivering coupons, and instead make that person a trespasser, and then make this scene more hazardous, make it occur at night in your mind. Take away the tape. Consider a totally black scene with no artificial light shining on the area. And then the question becomes, well, can that trespasser sue Mr. Masters because he was so negligent in guarding or warning against this hazard? He didn't have tape. He didn't light the scene. He didn't. All those things that plaintiff attorneys can think up that he could have done, should have done, but didn't. And the answer is no. You never get to the second question of did he do enough. The case question is answered by the first element. Was there a duty owed by the defendant to the trespasser plaintiff? The answer is no. You don't go any further. Case is over. Well, what's important for you to understand is that in evaluating cases, the open and obvious hazard rule is part of that duty element. So it's the first question that needs to be asked when you get a new suit or you get a new claim. Did the defendant owe a duty to the plaintiff? And the answer to that is if you're a premises possessor or owner and it involves an open and obvious hazard, there's no duty of care owed to the plaintiff. And the analysis of the case is made under that point number one in the hierarchy. Was a duty of care owed? If the hazard was obvious, the answer then is no, and you don't go any further and decide questions like, well, could the defendant have shoveled that snow sooner? Did the defendant do enough by placing salt on the common areas? You never get that far because the question number one to be answered is, was there a duty of care? The answer, if it was open and obvious, the answer is no, and the case is over. And why is that? Well, the Supreme Court of Michigan has simply made a policy decision that we are placing the sole burden to avoid hazards on the people confronting them and not the owner or possessor creating them, as long as the hazard is obvious. The policy is simply that people need to take responsibility for their own safety when they're on other people's premises. We're not going to go through the long history of the open and obvious hazard rule in Michigan because, quite honestly, the law is fairly settled now in most respects. This is a doctrine that is here to stay, but with the caveat that in Michigan, here to stay means only until the next judicial election for the Supreme Court. So let me just say that in recent years, these principles that we're going to discuss seem to be locked in place, and absent some legislative change or some great change in the Michigan Supreme Court, in all likelihood these rules are going to apply. So the first key case you need to know about is Lugo versus Ameritech. Most of you already know this, so we'll go through it fairly quickly. But you see, in the source of the current rule is found here. And so you have the Michigan Supreme Court talking about Ms. Lugo's case. So if you don't recall her facts, Ms. Lugo went to an Ameritech building, and she was in their parking lot walking along, and she was distracted by a truck that was turning into the parking lot. And as she walked and being distracted, she stumbled in a pothole, and she fell and injured herself. She brought suit against Ameritech, claiming that they created an unreasonable risk of harm by allowing potholes to exist in the parking lot where they knew or should have known that their customers were going to be walking. She contends correctly that she was a business invitee, that Ameritech wanted her to come into the building and wanted her to use their parking lot. And she claimed that based on that, they had an obligation to maintain the lot in such a way that it was safe for their business invitees. The Supreme Court dismissed the case. And the court, in doing so, said this, as you can see on your screen: if a person knows of hazards, or if the hazards are so obvious that they could reasonably be expected to discover them, the invitor, that's the business owner, owes no duty to either protect them or to warn them, unless, and then there's the exception, unless there are some special aspects to the situation, that it's still dangerous even if they know about it. We'll talk about that in just a moment. The court there left open the door just a little bit by creating an exception to the rule in the form of what is called a, quote, special aspect to the hazard that makes it unreasonably dangerous even though it's still obvious. Like trying to solve a Rubik's Cube, plaintiffs' attorneys have been trying for years to find that correct combination of facts that creates a special aspect in which a premises claim exists, even though the hazard is an obvious one. So we'll talk about that exception more in a bit, but first, in order to complete your basic understanding of this rule, you need to see this, Novotny. Now, the Novotny case actually preceded Lugo, but with that rule you just read, and in combination with the holding in this case, you have the open and obvious hazard rule as it is currently applied. So in the Novotny case, Mrs. Novotny was an elderly woman, and she was headed into the local Burger King. And because it's a business that complies with the Americans with Disabilities Act, in the front of the store was a handicap ramp, an incline that allows people to avoid having to step up steps to get into the building and instead use a ramp. And Ms. Novotny claimed she did not see the ramp and she fell. And the Michigan Court of Appeals dismissed the case. And they dismissed the case based on the open and obvious hazard rule. And in announcing the rule, they addressed her question. And her question is, how can you say that the open and obvious hazard rule applies to me when I have testified, and no one can refute me, that I did not see the ramp? The answer is, we don't care what you saw, ma'am. The question is whether an average person with ordinary intelligence would have been able to discover the danger and the risk presented upon casual inspection. That is the key essence of how the rule is currently applied. The question is not then what the plaintiff saw or didn't see. The court has adopted an objective standard, and the question then is, what would an ordinary person have seen upon casual inspection? And that extra phrase at the end is valuable in defeating lots and lots of cases, because it's not just enough would an ordinary person have seen it, but would an ordinary person have seen it if they were not just looking, but if they were inspecting for hazards as they walked. That's a pretty high standard that we have in Michigan, and so far it has remained good law. As you'll see, that case was decided in 1993, so that case has remained good law ever since. And so how has that rule been applied? Well, there's this famous case in Michigan where a blind person slipped on water in a restroom. And the case facts appear to assume that the water would have been obvious to a sighted person. And the question was, well, do we take into account physical disabilities when we decide cases under the open and obvious hazard rule? Physical disabilities like blindness. And the answer is no. The answer is no. The case was dismissed because the objective test announced in Novotny does not take into account physical restrictions of the plaintiff. The question of the case is simply whether the hazard was such that it would have been seen by an average user, not an average blind user, but an average user. The answer in this case was yes. An average person would have seen the water in the restroom. Case was dismissed properly. So we know then from Novotny that the law does not take into account physical restrictions in considering whether a reasonably careful person would have seen the hazard. Well, but what about age? To answer that question, you need to look at the next slide. That, I'm told, is a Jacob's ladder. I never played on them when I was little. I didn't even know what they were when I first read this case that's Bragan versus Szymanczyk Berry Farms. But apparently, a Jacob's ladder is designed for kids to fall off them. And in the case facts, the plaintiff, who was 11 years old, testified in his deposition that he knew what a Jacob's ladder was, knew that kids mostly fell off them. There was a pile of straw on the ground beneath the ladder, and the ladder was hung where its bottom rung was something in the order of 10 feet above the ground. And so in that case, the young man, Mr. Bragan, did what the other kids did, and sure enough, he fell off. And the evidence in the case was that 90% of the time, kids fell off the ladder. But in his deposition, the young man acknowledged he knew what the game was. He knew what the Jacob's ladder was designed to do. He knew that kids fell off, and he knew that if you fell off, you could get hurt. And so the defense brought a motion for summary disposition and said, like in the case of the blind person, look, this is obvious and would have been obvious to an average person upon a casual inspection. And in fact, we don't even have to worry about whether an average person would have known this was hazardous. We have the plaintiff's own admission by the young man that he knew what would happen when he climbed this ladder. The court, however, and I think it's simply a bad case, but nonetheless it speaks to the question of age in open and obvious hazards. The court said, well, yes, there are certain circumstances that we're going to consider in which age is a factor. And even though the young man knew what the ladder was and knew what could happen if he climbed it, he was of such an age that he did not sufficiently know the consequences of his actions. That is, he was unable to appreciate the dangers involved because of his lack of maturity. Now, this is a published case, and I'm surprised more plaintiffs' attorneys haven't used it more often, both in cases where plaintiffs who are children confronting hazards and older adults contending that they confronted hazards that may have been obvious, but because of their advanced age they could not have appreciated the hazard. So this is an area you have to consider when you look at cases involving open and obvious hazards involving very young children and very old adults. And the question there is, did they have sufficient maturity or mental capacity to appreciate the dangers despite the fact that the hazard was obvious to them? All right. So next we're going to talk about some misconceptions, and this happens all the time. The most common misconception that I see among claim representatives is that it's thought, well, this defense applies to every injury involving an obvious hazard. Is that true? No, it isn't. So I'll get cases, for example, or people will send me a file and they'll say, well, Tom, I have this case, and it involved a plaintiff that was involved in an accident in a road construction setting. But not to worry, you'll win the case because, you know, it was obvious. It should have been, the condition should have been obvious to that plaintiff motorist. Well, if your plaintiff is in a car and involved in a road construction accident, I don't care how obvious the construction warning signs were or weren't, this defense is not going to apply in that setting. Recall, as we discussed earlier, the case has to do, or must have to do, with invitees and licensees on premises, and a car driver is neither. I'll get cases, for example, involving dog bites, and I'll hear, oh, not to worry, Tom, even though the dog bit the plaintiff, it was an obvious situation. The dog was barking, the dog was snarling, the dog was obnoxious. The plaintiff knew that the dog had bitten 3 other people before, so this condition was obvious to the plaintiff. We should win on emotion, right? Wrong. No. Because no matter how obviously loud, obnoxious, or even vicious appearing your insured's dog was before the bite occurred, the open and obvious hazard doctrine does not apply to a dog bite case. Again, the rule applies to conditions on the land and things permanently attached to it, and the dog is neither. I'll get cases sent over in construction settings. And the question is, well, does the rule apply to a subcontractor working on a construction site? Now, it would seem to, wouldn't it? You know, after all, let's say an electrician stumbles and falls on a pile of wood left by the carpenters in a common work area. You'd like to be able to bring in the carpenters who left it there, or you'd like to, on behalf of the general contractor, contend that, well, this was an obvious hazard that the plaintiff, as a construction worker, was trained to see and avoid in common work areas. He didn't, so we win. But the Supreme Court, however, has simply, again, made a policy decision. In the case of Ghaffari versus Turner Construction, they basically said there, look, we settled this law a long time ago in a construction setting, and we've already enumerated in Funk versus GM and cases that came after it the various obligations of a general contractor in a construction setting, of subcontractors and owners and such, construction managers, And those rules that we've already set up are incompatible with the open and obvious hazard rule, and we're not going to change all that now. So it's just simply a fact. You need to know that in your average construction setting, where you have a subcontractor, an employee of a sub, attempting to sue, for example, the general contractor or the owner, that the open and obvious hazard rule will not apply. Many other defenses in that case, but this one is not one of them. Well, there's an icy, snowy parking lot. And if you've been in Michigan last winter, this was a daily scene for us. And the question is, well, who gets to claim the open and obvious hazard rule when the plaintiff is walking to, his or her SUV and falls in that situation? Well, we know that the owner of that commercial parking lot, we're assuming it's a commercial parking lot, the owner gets to use the defense. The possessor, let's say they have a property manager, they get to use the defense. See this guy in the middle? That's the snow removal contractor. He's there under a contract to remove snow and, let's say, apply a de-icer or salt. Does he get to use the defense? No. But it's a very common misconception by claims people, thinking that in an ice and snow situation, everybody gets to claim the open and obvious hazard rule. And the answer is that's false. The parties that do get to assert it are those who are in possession and control of the premises, and a snow removal vendor is neither. Now, he has other defenses. He may even have indemnity rights, indemnity protection in his contract. He may have a number of other rights that are provided by Michigan law. In Quinlivan, for example, absent some contract require him to do otherwise, in Michigan you don't even have to begin clearing snow until a reasonable time after the storm ends. And you see the storm is going on here in this photo. It's a great picture. So many other defenses, but can he say, well, geez, you saw the snow, it was obvious, I win because I owed no duty to you? And the answer there is no. The key is whether or not the party being sued had the possession and control, and that means whether that party had the right to direct the activities on the property to the exclusion of others and to control its condition. So let me give you another example where it would apply. And this is the case, Anderson versus Wiegand. You may or may not know, but in Anderson versus Wiegand, Mr. Wiegand owned a house in Grosse Pointe, and he was selling it. And he wanted to be away for the weekend because his real estate agent was having open houses on Saturday and Sunday. And so he left town with his wife. They went to Ohio to visit family, leaving the key with the real estate agent. And in the course of an open house, the plaintiff slipped and fell on ice on the walkway leading up to the porch, the main entrance into the house, fell, badly fractured her ankle, and then sued Mr. Wiegand, and then sued the real estate agent. So in this context, did the open and obvious hazard doctrine apply to the real estate agent? And the answer is yes, because in that setting, having the key and having the ability to shovel and salt that walkway, that ability left to him by the homeowner, the real estate agent in that context was in possession and control of that entranceway, could have, so he had the right to apply salt and shovel the snow. And so in that situation, the ice being obvious, the real estate agent was then in a position to move the court for summary disposition, asserting this rule, and was successful. Right, the next big category of misconceptions is that if some claims by your insured, if some claims against your insured are barred, then by rule all claims against your insured are barred. And that's false as well. The law distinguishes between general negligence claims and premises claims. So you know what a premises claim is by now. I've said this several times. It's a claim arising out of a condition on land or something permanently attached to it. But that does not constitute the entire universe of claims that can be asserted against a person. So then what's a general negligence claim? It's a claim of simple negligence arising out of someone's conduct as opposed to a condition on the land. So a general negligence claim is a claim of simple negligence arising out of someone's conduct and not arising out of a condition on the land. And as a result, in Michigan, the open and obvious hazard rule is not available to a defendant in a case where a claim is made of simple negligence. Now, the way complaints are drafted, your insured may have a multitude of different theories asserted against him or her, some of which may involve a condition on the land, and some of which may involve simple negligence or general negligence. Some claims may have the open and obvious hazard available to it, but others may not. And you have to look carefully to see what it is that's being asserted against your client. So let me give you an example. That is a front-end loader. In the case of Lair versus Kitchen, the plaintiff was helping the defendant work on a front-end loader whose hydraulic system was not working well. And a hydraulic system is the thing that helps make the bucket go up and down. It's an oversimplification, but if your hydraulic system isn't working, the bucket's not going up and down the way you want it to. And so in order to work on the bucket and the truck and its hydraulic system, the owner of the truck, the defendant, your insured, lifted the bucket like 5 feet in the air. He was able to get it up that high and then locked it into place, or he thought he did. And so then the plaintiff got underneath and was going to help him fix the hydraulic system. But of course, the hydraulic system was in bad condition, and the bucket fell on the plaintiff. So the question is, well, wasn't that obvious? So in the case facts, the plaintiff knew exactly what was going on. He knew about front-end loaders. He knew about hydraulic systems. He knew that this particular truck had a problem with the hydraulic system. He knew the consequences, or at least the potential consequences of that. And he could see that this bucket was 5 feet in the air. So he had actual knowledge of the hazard. And the question is, well, why doesn't the open and obvious hazard rule dismiss that case, given what we know about the policy of people taking responsibility for their own actions and shifting responsibility to them and not the premises owner or not the defendant? Well, the court simply held that, in this case remains good law, that this is not a case involving a condition on the land, even though, of course, the front-end loader was on defendant's property at the time. But they said this is not a case about a condition on the land or something permanently attached to it. Instead, it's a case where the defendant's conduct was at issue. That is, why did you raise the bucket knowing that the hydraulic system was not functioning correctly? And by doing that, defendant, you created an unreasonable risk of harm. And the court said you cannot use the open and obvious hazard rule to defeat that claim under that circumstance because it's not a premises liability claim. So what's happened because of that rule? Well, what's happened is that plaintiff attorneys are now using creative writing to try to draft their way around premises liability claims. So, for example, instead of saying that the premises was defective due to the presence of ice and snow, the plaintiff will allege instead that you, defendant, property owner, you were negligent in hiring an incompetent snow removal contractor. Or you, defendant, you were negligent in failing to train your employees to inspect and remove snow and ice. Or you, defendant, failed to supply adequate supplies of of salt and shovels to your employees and contractors, thereby creating a hazardous condition. So the goal of the plaintiff's bar appears to be then, as you would expect, to try to draft their way into a general negligence claim as opposed to a premises liability claim, because they know their premises claim is likely going to be out the window. But so far, I'm happy to tell you, the courts have taken a pretty rigorous view of these pleadings and have seen them for what they are. And courts are looking behind the pleadings to see that what's really being claimed here is a premises liability action. But plaintiffs keep trying, and you'll see that in your work as you review complaints in a premises setting. You'll see quite often all these added other theories, and now you'll know why they're there. All right, so how do you determine then whether the open and obvious hazard rule applies? You just have to answer these two questions. Does the claim involve your insured's possession and control of real property, that is real estate, and those things permanently attached to it? Is this a claim, and number two, is this a claim for general negligence, or is this a premises liability claim, number two? All right. All right. All right, next I want to talk with you about the current state of Michigan's law in the context of snow and ice cases. On your screen now is a quote from the dissent in the case of Kenny versus Katz. And why am I quoting for you the dissent in a 2-to-1 opinion where the plaintiff won? Well, I'll tell you in just a second. Michigan this last winter experienced its snowiest winter since records have been kept in writing. But I guarantee you that when lawsuits start coming in, all slip and falls will have been on black ice last winter. And no plaintiff's attorney, oddly, will have a single photograph of the condition on which the plaintiff fell. The reason is that if you can see the hazard in a photograph, it's quite likely to have been an obvious condition, and plaintiff attorneys are not in the habit of creating evidence to help you file a motion for summary disposition. So what's behind this current tactic of asserting everything is black ice? Black ice is the last vestige of slip and fall cases in Michigan based on slippery winter conditions. Now, the Court of Appeals has said correctly that black ice, by definition, blends into the surface it's frozen to and cannot be readily seen. Therefore, by definition, black ice is not obvious. So that case, the Blarney Oil case, but regardless, there's a case that really helped the plaintiff's bar by saying, as a matter of law, black ice is invisible. And after that case came out, every slip and fall in Michigan occurred on black ice as described by plaintiffs and their attorneys. All right, then along came this case of Kenny versus Katz, and this case at the end of the appellate process, because it went to the Court of Appeals, then to the Supreme Court, then back to the Court of Appeals. So at the end of the process, this case pretty much settled the law of ice and snow slip and fall cases in Michigan. And what the Supreme Court did was to adopt the defense. That's why this is here. So the Supreme Court adopted, the dissent in the Court of Appeals decision. So Kenny versus Katz, there were several elderly women headed to a funeral home at nighttime, and it was snowing, and they could see by their headlights that it was snowing at the time, snowing lightly, but snowing nonetheless. They pulled the car into a funeral home parking lot, and Ms. Kenny was the last one to get out of the car. And as her friends got out of the car, she could see that her elderly friends were holding on to the side of the car as they walked past. Then Ms. Kenny got out of the car and fell, and she claimed that she fell on black ice, that she couldn't see it, it was nighttime, etc. In a 2-to-1 vote, the Court of Appeals upheld the verdict for the plaintiff. However, the Supreme Court reversed and adopted the dissenting opinion and dismissed the case. And what this dissent was saying, as you'll see here, is that, and this is the judge writing, you'll see I have it in bold and in the last part of this quote, in my view, after witnessing 3 companions exit a vehicle in the snow-covered parking lot on December the 27th, and seeing them hold on to the hood of the car to keep their balance, all reasonable Michigan winter residents would conclude that the snow-covered parking lot was slippery. So how does this decision then affect how we view the prevalent claim by plaintiffs that all slip and fall accidents in winter occurred on black ice? And the answer is this. You look at the Court of Appeals decision, and they're looking at other factors, what are called indicia, indications, indicia of winter weather. And what the justice or the judge here is saying in the dissent is it's December the 27th. It's wintertime in Michigan. And the plaintiff saw a snow-covered parking lot while she was still safely inside the car. And she saw her friends holding on to the hood of the car to keep their balance. And so the court is looking to other factors to answer the question, would a reasonably careful person of average intelligence upon casual inspection have been able to appreciate and avoid the hazard? And the answer is yes. So in this case, basically the court is saying, Ms. Kenny, you did not have to get out of the car. You know, no one forced you to go into that building. You made a decision, and your decision was to encounter that hazard, and in doing that, you fell. And in this circumstance, the premises owner did not owe any duty of care to you at all, and your case is dismissed. So the bottom line is, how do you approach these cases? And the answer is this. If the only indicia of winter weather is an isolated patch of black ice, nothing else going on to suggest winter weather, you're probably going to lose, or at least they're going to get past a motion for summary disposition. I suggest you win the case on other grounds. But if the only thing that's present at the time is a patch of black ice that the plaintiff claims could not see, and there's nothing else going on, you'll probably lose the motion. But if there's other evidence that winter is sort of happening around this plaintiff, and those things might be the presence of snow flurries, you know, the presence of snow piled up around the edges of the property, you know, sleet, it could be just so many other things, that cold temperature, the more indications of winter weather there are, the more likely that the Kenny versus Katz rule is going to apply. Right? And so that a reasonable person who is a Michigan resident would know that there's likely to be the presence of slippery conditions. Generally, even if we accept that that person did not see the actual hazard that they slipped on. All right. So your job as a claims representative is to help your attorney uncover those winter weather conditions when you get the claim through the weather records. In the case of a commercial building, perhaps they have a video surveillance films that show the parking lot, witness statements, and things like that. So the goal then is to find other indicia of winter at the time the plaintiff claims his fall was isolated on a single patch of ice. Even additional patches of ice, as odd as that might sound, will help your defense. All right, I want to loop back around then, because I told you earlier that the Supreme Court in Lugo had created an exception to the rule, so we need to talk about that so you understand it. And you'll see I put on the screen again the holding from the Lugo case, and the court talked about some special aspect of the condition that might make the situation particularly dangerous, even in the case where the plaintiff knows about the hazard. So the special aspect exception to the open and obvious hazard rule assumes that the plaintiff, or a reasonably careful person, would have seen the hazard. But the question then is, are there any circumstances where a person knows of a hazard and he or she can still get past a motion claiming that the defendant should have done something, even with respect to obvious hazards? And the court in Lugo gave two examples of possible scenarios in which that exception might apply. In the two examples the Lugo court offered, one, a person falling into a deep, unguarded pit. The court said that even though the pit may be obvious, if it's unguarded, it would cause a high likelihood of injury unless the defendant premises owner took steps to protect people from it. Now, plaintiff attorneys have not succeeded in finding this example to their advantage. After all, there are simply not many situations where this level of hazard is present and unguarded. The second one has been more profitable for the plaintiff's bar. The Supreme Court spoke of an unavoidable encounter with a hazard and described a situation where a person was effectively trapped and needed to encounter the hazard because there was no alternative. The court described a shopper in a store that had only one exit, and the floor near the exit was covered with water. Even though the shopper knew that the water was present and knew that the hazard was obvious, the shopper had no choice but to walk on the water, and then lacking the ability to walk on water, the shopper fell. Plaintiff's attorneys have been trying to use this example in many creative ways, but with limited success. The cases that have rejected their attempts have all involved the plaintiff trying to get into some sort of a business. For example, the claim might be, I had to go into the gas station office to pay for my gas, therefore the ice that I saw it was unavoidable and I had to walk over it. Rejected. I had to go into the building where my gym class was being held. I had to go to the mailbox because that's where my mail is, and I had very important mail I was waiting for. The response to all those kinds of claims is no, you really didn't need to go where you're claiming you needed to go. Instead, you made a choice to encounter the hazard, and that the Supreme Court's idea of an effectively unavoidable hazard does not apply to those situations where you're trying to get into some place. Now, the most recent case that really talks about this is the Hofner decision by the Michigan Supreme Court. And this was a 2012 case, so it's published, Supreme Court, it's the final word, and it's very helpful to the defense. And so what the court is saying there, again, this is a situation in Hofner where the plaintiff was trying to get into a building. And what the court said, you'll see I have it in bold at the end there, the fact that the plaintiff, who was a business invitee, had a contractual right to enter the premises does not mean that she was unavoidably compelled to confront the icy condition. So particularly in cases where the plaintiff is in a car, it's almost impossible to contend that you had to utilize whatever services that you're utilizing. You could just drive your car away. But also in terms of being on foot, the claims have been rejected uniformly that you had to get into the building. Now, I'm waiting for the hospital case where someone needed to get into the emergency room and there's no effective alternative other than to go in there and then being confronted with a hazard. I suspect that claim might prevail. We haven't seen that yet. That's just my prediction. All right, so the one other kind of case that has gotten some discussion is involving store displays. In 2007, the Kennedy case was decided. It's Kennedy versus A&P. And prior to that time, there was this distracted customer doctrine that some other states have adopted. Michigan had sort of alluded to it, but never had formally adopted it. But it sort of goes like this. If you want me to be looking at the floor when I'm in your store, then don't put up advertising and product that tries to capture my attention above floor level. And that has worked in other cases in the past, even in Michigan, where the claim is, well, you should have seen, in the Kennedy case, the grapes on the ground. And the answer is, well, okay, maybe, but you shouldn't have been offering me 10 cents off peanut butter right in front of my eyes at the same time. But the Kennedy case adopted the open and obvious hazard rule, and correctly applying the standard of a reasonably careful person, they rejected the claim and dismissed the case. But most recently, in the case of Quinto versus Woodward, Detroit, CVS, the plaintiff went into a pharmacy and fell there, and in the course of shopping at the pharmacy was distracted by an end cap display. The Court of Appeals said, look, except for the Kennedy case, we would recognize this cause of action. But we're not going to, because we, as a Court of Appeals panel, are constrained by rule. We must follow prior published precedent, and we will follow Kennedy. But if you were to ask us, we would create a new rule and adopt the distracted customer rule in response to open and obvious hazards. And the Court of Appeals in the Quinto case recommended that the case be reviewed, what's called en banc. It's by all the panels of the Michigan Court of Appeals, but that suggestion was rejected. So Quinto is still good law. It is probably subject to additional litigation, but for now, you should win those claims in this kind of setting. All right, that's our presentation. Thank you so much for listening. Again, I'm not able to answer any questions that you have now, but if you'll email me or call Mark Masters, call one of us, we'll be sure to answer any questions that you have or get any materials to you that you need. If you want to see any of the actual cases that have been discussed, let us know. We'll be happy to get those to you. All right? Very good. Thank you. Bye-bye.